Mr. McFarland, which case are you here on?
I am here for Allen versus Mullins and Ajax.
All right, so you're here for Connoten?
Yeah, I'm filling in for Tim Kanata.
Okay.
Yeah.
So you're here for Mullen and Ajax, correct?
Correct, yes.
Okay. Thank you. Hi, Mr. Vanchek. You're here for Mr. Watts.
Yeah.
All right, we're waiting for the other attorney to appear.
Okay. If you wouldn't mind, can you throw me a breakout room with my client, and I think his mom is here as well.
Yep, sure. I'll throw you in. Are you ready on Seawine?
Yes, we are.
You ready to see the judge?
Yes.
All right, it'll be just a minute.
Oh, yeah, I can go there. The other one. This one.
Hi, Melissa.
This one.
Good morning.
Good morning. When the attorney's done speaking to his clients, did you want to speak to Mr. Ivanchek?
Yes, that'd be great. Thanks.
Okay, thank you.
Yeah, see if it's in there, then might need to get processed or printed. Yeah. Heather, you got one for me?
I do, Judge.
Did you put it? Sure. Is this my copy? Yeah. Thank you. All right, I am ready for an appearance on alternative lending versus Seawin.
Good morning, Your Honor. Mimi Kalish. My P number is 52383 on behalf of the plaintiff.
Thank you. Mr. Seawin, if you've got a camera to activate, please do so. And you're muted.
Thank you. Good morning, Your Honor.
Good morning, sir. Do you have a camera you can activate, sir?
No, I do not.
Okay, no problem. All right, Mr. Am I saying your name correctly? Is it Seawin?
Cyan.
Cywin? All right, sir.
Cyan.
Today's the day. Say it again.
Cyan.
Sounds like you're saying Styan.
No, it's Cy. S-E-Y. Cyan.
Cyan. All right.
There you go.
Today's the date and time set for a pre-trial. That gives me an opportunity to get some information about the file. So hopefully we can put it on a calendar and move it towards the resolution. Counsel, where are we at on your end?
Your Honor, Mr. Cyan is not disputing the debt. This originated as a loan, a consumer loan. He is working with a debt consolidation company. We have not resolved the matter. I explained to him in the breakout room that we would likely be filing a motion for summary disposition.
Okay.
And I believe that's how the matter is going to proceed if the court wants to open discovery in case Mr. Cyan wishes to see documentation, but it doesn't appear that he's disputing the debt.
Okay. Do you need any discovery on your end?
No, sir.
Counsel?
I don't think we do, given that Mr. Cyan is not disputing the debt.
Okay. So why don't you just motion it up for a motion for summary disposition?
And when does the court hear those?
You'll have to contact the clerks to schedule.
Very good. Thank you, Your Honor.
You're welcome, counsel. Mr. Cyan, do you have any questions about how the process goes from here?
Will they notify me?
Absolutely. Yeah. Yeah.
Okay.
What's going to happen is counsel's going to draft a motion for summary disposition. I don't know if she explained it or not, but basically that's a motion is just a word we use in the legal profession to say request. So basically their argument is that there's no material issue at dispute, and the facts that apply to this case with the law that applies to this case, they're entitled to a judgment at this time. They'll file a motion to that effect. They'll submit it to the court. They'll send a copy to you. You'll get that motion and a notice of hearing. You'll have a chance to respond to that in writing, and you'll also have a chance to respond orally at the actual hearing, which we'll do like this on Zoom. You understand that?
Yes, sir.
Okay. Do you have any questions about process?
No.
Okay. Counsel, anything else?
Nothing further, Judge. Thank you.
All right. You two enjoy your day.
Thank
Okay,
you.
thank you, sir.
Judge, all the other ones, we only have one party each, so we're just waiting for other people to appear.
Gotcha. Thank you.
Yep. Mr. Ivanchuk, I have,
Yeah, Melissa, you can
yes.
put it in the room. That's fine.
Thank you. Hi, on the computer. What's your name, please?
Daryl West.
All right. All right, Mr. West, I'm going to put you back in the waiting room, waiting for closer to your time for your hearing, okay?
Want me to just leave and come back?
That's up to you if you want to. Just check in at like 20 after 9 maybe.
Okay, I'm gonna do that then.
All right, thank you.
Yes, ma'am.
Mr. Ivanchek and Melissa, I don't want to say your name wrong, sorry.
That's
Are
okay.
you guys ready to see the judge, or do you
We
need to
are.
speak to
Yeah,
your
we're-
clients again?
Yeah, can you drag them back in here? I
I
think they might
sure
not have left the
will.
room.
They did not.
Thank you.
Thank you. Appearances on Concordia versus Watts, please.
Good morning, Your Honor. Melissa Pranzals on behalf of the plaintiff.
John Ivanchek on behalf of the defendant, Your Honor, who's here, and his mother's also here watching.
All right, thank you. All right, date and time for pretrial, correct?
Yes.
All right, so where are we at?
Your Honor, we had previously adjourned this for 3 months to try to resolve something. I think we're closer than what we were. If we wouldn't mind, or if the court wouldn't mind, just give us about 2 weeks and have us back if we don't settle it before then.
Another pretrial, is that what you want to do?
If the court wouldn't mind, yes.
Plaintiff's okay with that?
It's okay, Your Honor. Thank you.
Judge,
Heather,
we
what's
have
our next
March,
date we can get?
It's March
Go.
12th.
March 12 work for you too?
Hold on.
It's okay for me.
I have a case evaluation that morning starting at 9. Yeah, you know what? It's 9:15. I think if we're starting at 8:30, we should be fine. So,
Yep, you can do 8:30.
yeah, that'd be fine.
All right, so we got you on for March 12, 8:30.
All right, thank
Thanks,
you.
Judge.
Wonderful. Enjoy your day.
Thanks,
You too. Bye-bye.
Mr. West, you're here already, and Miss Coyle, for Sealmaster, did you guys need a breakout room?
I don't need one.
No, we just need to proceed with the motion, Madam Clerk.
Judge, that's at 9:30. Did you want to start that one now?
We
They're
got
both-
everybody we need?
Sealmaster, and Daryl West. Yep, we have Miss Coyle for Sealmaster.
All right, cameras activated, please, if you can. Mr. West, are you out of the hospital?
Yes, sir.
Good, good. Do you have a camera you can activate?
I don't know how to do it.
Okay. We can get by without. All right, so I'm testing my memory. I think this was the date we were gonna hear Mr. West's motion. Is that correct, Mr. West?
Yeah, Judge, but I'd like to add a second motion where I'm requesting the court to enjoin the second plaintiff, which is the property owner. They'll be present at 9:30 if you need him present. But
All right,
I believe he's a
Did that-
necessary joiner in the case.
all right, did that get noticed up?
No, Your Honor.
I'm not
You
sure.
didn't schedule that one for today, Mr. West?
I was gonna do it on oral motion.
Okay, well, plaintiff's still gonna have a right to respond and prepare a response to that. Counsel, I'm assuming you're not ready to argue that motion?
I am not, Your Honor. This is also the date and time set for a motion to dismiss for lack of service. If that motion is granted, certainly the property owner can join in the next suit that Mr. West would file.
All right,
Judge.
so you've got a
Yeah.
motion up. Hold on, Mr. West. You've got counsel, you've got a motion up for dismissal for lack of service.
I do, Your Honor, and for lack of standing.
Right?
And then
All right.
in response to that motion, we received a motion to quash our limited appearance and a second amended complaint / response to the motion. And then we received a couple supplemental responses or exhibits from Mr. West. We did receive the motion to allow the joinder of a party, but we didn't ever receive a notice of hearing on it.
Right, right. And Mr. West, you've got a motion up,
Quash.
saying that the law firm is improperly handling this as a limited appearance, correct?
Absolutely. Not only that, Judge, I don't believe either the defendant listed on the pleadings nor counsel have standing to pursue any arguments before the court, because if the court would refer to the name of the company that they're representing, which is PMGSM MILLC, that's not even a material supplier. That's a trucking company that's listed on the government snapshot information. So I didn't do business with PMG. I didn't buy nothing from PMG. PMG is not a proper defendant in this complaint, and they should be removed from the complaint along with counsel, because counsel represents PMG. I mean, I could sue a million different companies in Michigan, none of which are the actual defendants in the case. The defendants in this case are Sealmaster. I listed LLC because really it's a DBA, but it's under the umbrella of an LLC for Gem Seal. So Gem Seal and Sealmaster are the proper defendants, and I'd ask the court to strenuously pursue requiring the proper defendants be listed in the pleadings.
Okay, but what you just told me is the defendant you listed doesn't even exist.
No.
There is no Sealmaster LLC, correct?
Say that again, please.
Is there a Sealmaster LLC? Is that an entity registered in the state of Michigan?
Absolutely. I've given the court the documentation from Laura, which shows all 5 different Sealmasters in Michigan. And
okay, you just said, but you just said the words out of your mouth were Sealmaster's a DBA from some other entity that's an LLC.
Same, it's a Gem Seal. That's right. It is not PMG. That's what I'm stressing to the court.
Okay, so there is no Sealmaster LLC. There's a Gem LLC that has a DBA of Sealmaster, correct?
That's right. That's right.
All right, so there is no LLC, the legal entity of Sealmaster Limited Liability Corporation in Michigan.
Well, that's a matter of interpretation. As I look at the business entity.
No, it's not. Is there a LARA document that shows Sealmaster, LLC?
It actually shows the identification number for Sealmaster DBA under the LLC Gem Seal.
Then that's not an LLC named Sealmaster.
Okay.
So
okay,
why,
well,
counsel, I'm confused why anybody's defending a defendant that doesn't exist. Let him have a judgment against Sealmaster LLC. It doesn't exist.
Your Honor, the issue that my client runs into is its DBA is Sealmaster Detroit. And when we get a motion for entry of default judgment against an entity that is Sealmaster, we need clarification as to whether that would at any point relate back to our client. Sealmaster Detroit is a DBA of my client, PMG SMMI LLC. And so out of an abundance of caution, my client hired me to file a limited appearance to challenge the service issue, which has not been resolved, and to also ensure that it nor Sealmaster Detroit would be involved in this litigation. And what we thought or presumed would have happened is that Mr. West would have amended the complaint to include the proper defendant based on the allegations in our motion. But in looking at the record further, and the reason that we filed a motion is that he didn't serve anyone correctly. And so all of the defendants should be dismissed and the case should be dismissed.
Well, there is only one defendant. I
Well,
don't have a complaint with any other name but Steelmaster LLC.
we received a second amended complaint. And I'm trying to pull it up now, Your Honor.
Judge, may I respond?
No,
Okay.
We received a second amended complaint. Count 1, product liability negligence. Count 2, destruction of property, response to defendant's motion. It looks like it was postmarked November 28th, 2023. It doesn't appear that it's a filed copy, so I don't know if or when the court received it. But it lists Sealmaster, paren DBA, and paren pavement products and equipment, and Gem Seal
In the case
pavement
heading?
products. Yes.
that's in the case heading.
Correct.
I'm still looking for that.
And unfortunately, I can't point the court to a specific date because we don't have a time-stamped copy. And the cover letter was not dated. Let me see if there's a proof of service at the end of it.
I've got a fee waiver request that lists defendant as Sealmaster DBA Gem Seal PMGSM Michigan LLC.
That's the proper name from the plaintiff.
All right, I've got a motion that's got that listing. I'm still trying to find an amended complaint.
And at this point, it's really a case of misnomer on the name of the defendant. And I just asked the court to amend the heading to Sealmaster Gem Seal LLC.
All right, so I found what's labeled a second amended complaint. The defendant, Sealmaster, DBA, pavement products and equipment, Gem Seal. Once again, that language isn't correct either, counsel.
Correct, Your Honor.
You know what, Mr. West, I'm dismissing all your actions. Get it right. File a summons and complaint that has the actual language that Larry uses for these corporations and these companies. It's not that complicated. This is not your first rodeo. You know how this has got to be done.
As long as you do it without prejudice, I can start over.
It's absolutely without prejudice.
Yes,
Get the parties right so we can move forward.
I can do that. And at that same time,
All right.
I'll include the homeowner also.
Your Honor, if I can clarify for the record, will the court be issuing that order or do you want me to draft one and submit it?
If you want me to issue a paper order, somebody drafts it. I don't draft orders.
I understand. I'll draft it and send it to the court. Thank you, Your Honor.
Okay. All right. Thank you.
Thanks, Judge.
You're welcome. Good luck with your health, Mr. West.
Thank you.
Judge, so
Yes.
Midland versus Mundy. Mundy has not appeared.
Okay.
And then the next one, Allen versus Mullins and Ajax. Marty Allen has not appeared.
All right. So who's representing Midland Credit today?
Good morning, Judge. Andrew Perry, P69402 on behalf of plaintiff.
All right. And this is Mundy's Objections to garnishment?
Yes, Judge, she filed an objection to garnishment indicating there was a payment plan. Since filing the objection, Judge, the garnishment satisfied the judgment. I released the wage garnishment, and just a note, there was no payment order on file.
All right, so that's probably why they didn't show up, because it's kind of a moot point.
I agree. But I just wanted to make
Yeah.
sure that it was clear that the plaintiff could retain the garnished funds.
Yeah, I'm just gonna note that defendant didn't show up, objections ruled invalid.
Okay. And then I think I still have to file a satisfaction of judgment. I'll try to get that filed this week.
Yeah, we always want to see those.
Okay. Thank you, Judge.
All right, anything else?
No, I'm all set.
Have a good one.
You too.
And I'm sorry, Heather, what'd you say about Allen versus Mullins?
Alan failed to appear, but the attorney for Mullins and Ajax is here.
All right. All right, counsel, your appearance, please.
Good morning, Your Honor. William McFarland on behalf of defendants Mullins and Ajax.
All right, counsel, you filed a motion for summary disposition today.
That is correct, yes.
Have you seen any kind of written response from Allen?
I have seen no response of any sort.
Your motion is granted.
I'll submit an order to that effect later today, Your Honor.
Have a great day.
You as well.
And that's it for now. I'll be checking everybody else in. Alexis, your
Thank
last
you.
name is Smith.
Smith's last name was Smith.
Okay.
Alexis?
Hi, yes.
All right, I just wanted to verify that. Okay. Mr. Goldman, who are you here for?
Your Honor, I'm here for the plaintiff, Rock Creek, on the Alexis Smith case. She's
All
a
right,
defendant.
did you want to speak to her in a breakout room?
Sure,
All right.
please.
Yep. And Mr. Duquette, you are here for Discovery Bank or for Keith Holmes?
Discover Bank.
Discovery Bank. Okay.
I don't think counsels for Mr. Holmes is going to appear. We actually submitted a consent judgment yesterday. We e-filed that, so I'm just here to see if the court has received that.
Let me see. Attorney called today, submitted, advised it has not been processed. It just says that it hasn't been processed yet, and for you
Okay.
guys to appear. So we'll be waiting for the other party.
Okay, sounds good.
figure I might as well take care of some signing on days. Mr. West, his hobby is selling people. Yeah, I'm starting to think that. Was created. Doing. Okay. Which one? Alternative? Yes. Plaintiff is going to file a motion for summary disposition. Still won't come up. Hey, I got a question for you. We're up here just killing time waiting for files, and I thought I'd get in and sign some stuff. Nothing's coming up. Yeah, so I'm in judge review. It's showing me all these files with my name on them. I click on a document and nothing happens. I'm a reviewer. Nope, that was it. Okay, thanks. Okay. All right, any idea how I get this back up? Where is it over here? So, that document did go. Maybe carpal tunnel.
Judge, for the discovery versus Keith Holmes,
Yep.
at 9 o'clock, Mr. Duquette is here. They submitted a consent yesterday. He wasn't sure if they still needed to come on today because it's not in the system yet, but they did submit.
No, that's all right, as long as we get it.
So do you want him to wait around or?
Just, council, just chat Heather a good phone number in case somebody shows up from the other side. If they've got a different story than what I got from you, we'll call you back and we'll get it hammered out.
Okay, sounds good. I will let Diane know.
Have a great day.
You as well.
I'm going to step away for a minute, Judge.
Okay, Malachi's got it under control. Yeah. The first case I had with Mr. West, he had sued, it was a marina. Yeah, it was a marina. He had some work done on his boat. And it was a Judge Green case. So I mediated. And I got the plaintiff to settle case, give money, you know. And he just thought I was greatest. But I told the guy, I said, you really want to go back and tell your client you have to spend money to prepare for a trial with this guy? And then you can spend probably a full day here in trial because of, you know, the way he is. I'm like, what's it going to cost you to charge him just for trial prep? 10 grand? He said, well, I don't think it'd be that much. I said, it's not going to be too much less than that, is it? He said, well, probably not too much less than that. I'm like, then throw the money at him. I said, I know you don't want to because you don't think you've got a loser. I said, but it just doesn't make sense business-wise. So Mr. West just thought I was the greatest. And I'm thinking, it's not like because I believed in your claim, dude. I mean, I didn't tell him that. It's like, it's not because I think, you know, he was, one of the things he was suing for his son lost his thumb because they took the boat out, and he claims because the boat still did work and the kid got his thumb caught in the rope and he lost his thumb. You're never going to be able to prove the connection back to the arena. Okay, I hear you. Jeez, like, yeah, that was crazy. He is a character, though. No, it was his hobby before that. Oh, really? Yeah. As a matter of fact, the attorney on the other side had done some research. And he's shown me all these different lawsuits where the guys following. Like, yeah, okay. You know, some people do woodworking.
Mr. Goldman, are you and Miss Smith ready?
Let's see, play for signature. What's the motion? That's why. See if they file it.
Miss Smith, did Mr. Goldman said he was going into another court or something?
No, he had told me that he was leaving the breakout room.
Okay. Oh, I don't.
All right.
Yeah. Okay. So who am I supposed to sign it? See, it doesn't give me this. Oh, here it is. So you send it to you guys. I'll do that. See, the stuff up here is gone.
Mr. Goldman, are you ready?
Yes, forgive me. I don't know why my Zoom camera is not working. Breakout. Can you hear me okay? I went to.
Yep, we hear you.
Okay, thank you.
Judge Rock Creek versus Alexis Smith is ready.
This way? Yeah. All right, what one was that one?
Rock Creek Capital versus Alexis Smith.
All right, appearances, please. We
Your
lost
Honor.
our Zoom. We're gonna try to get it out here.
Your Honor, Daniel Goman, P4 231 for the plaintiff, Rock Creek.
And Ms. Smith, can you hear me okay?
Yes.
Okay. And counsel, what do we have today?
Your Honor, the court had scheduled this for a pretrial. Your Honor, we had filed a motion for summary disposition that is set for hearing today. I discussed that with the defendant in the breakout room. Her position, if you look at her answer, was that she admitted to everything in the complaint. The only defense was she argued a statute of limitations that we sued 6 years after the contract. I advised her that she should have reviewed that I understood her argument. She was polite, respectful, but that as explained in the motion for summary disposition and in our brief, Your Honor, starting on page 8 and going on to page 9, we explained that because in this case there is a note as well, that we are allowed under the law to sue under the note. That argument, Your Honor, is laid forth in there. I could read it, but it starts at the bottom of page 8. And so we had until June 30, 2024, 6 years from the charge off date on the note to file the suit. In fact, we filed it on October 20, 2023, which was timely. And we are only seeking the missed payments from that date looking back, which is why the amount sued for of $2,917.44 is less than the ledger balance of $3,171.98, because plaintiff is only seeking the 32 missed payments, see paragraph 8 of the complaint, that occurred years prior to the filing of the complaint. So I advised the defendant in the breakout room and that was our position, and that my job was twofold. One was to get a judgment so that we didn't have to deal with a trial and the litigation. And then once we had a judgment, is to work with her on a payment plan. She's explained that she's in nursing school, which is noble and great, and not in a good position to pay. And we did that. I told her there were options that we could deal with. In fact, she had contacted our office, and I won't go into it too much, but we had sent her a proposed consent judgment and a payment plan. But I think she was just going to try and do the 6-year statute of limitations defense. I don't blame her. I don't think it's going to be successful, respectfully. But anyway, that's our position, Your Honor. We think that circumstances, certainly given the answer, given the statute of limitations law, that a motion for summary disposition is warranted, and that summary disposition should be entered into a judgment. And that's what we're requesting.
Thank you, counsel. So today what we've got scheduled is a pretrial and your motion for summary, correct?
Yes. Sorry, yes.
Okay. All right, Ms. Smith. So a pretrial is just an opportunity for me to talk to the parties, get some information about the file, and hopefully move it down the road. Because we've got the motion up today, that might be the end of the road. So I'm assuming you received a copy of the motion that was filed by plaintiff, the document itself. Yeah. Okay. I do not see that you've responded in writing to that motion. Is that correct? Or do I have to find a document you sent us?
No, I did not respond to it.
Okay. All right. So I'll give you a chance to respond to that motion orally today before I make a ruling.
Okay.
Go ahead. Tell me whatever you want me to consider before I make a decision.
Oh, okay. So, yes, Your Honor, I mean, I'm sure you probably heard this before. I am a single mom, though. My job currently, I was working with kids that had autism, and I got laid off from the position that I was in. Just because of no schedule, they didn't have a schedule for me. So right. I've had a really hard time these last couple months actually being able to find a job. I'm like on government assistance and stuff right now, Section 8. So right now I'm just trying, I'm in school for nursing. I am trying to turn my life around. I'm not just trying to run from debt and stuff like that, but I definitely don't want to enter Wayne Community College.
Good. How far into the program are you?
So right now I'm taking my prereqs to get into the LPN program. My deadline is to submit my application by May 15th, and then the program starts in May. So,
okay,
I'm sorry.
Go ahead. Continue.
But yeah, so as you see, I'm definitely trying to turn my life around and stuff, and these college debts and not knowing too much about credit and debt. I wish I did know. But right now I'm just not in a position to really be able to go into an agreement with somebody, because I understand that there's interest that comes with that. And then if I don't pay, that's a whole nother situation. And I do have a history of going back and paying my debt down. You can, pull my credit report and see I have good credit. I've repaired it over the years. I've been paying back debt that I owe from my early days when I was pregnant with my son. I wasn't working. I was in a bad relationship. So I went back and paid down some student loan, credit cards, all that. I mean, I really don't have no debt like that except for student loans. So I just need time. I mean, I have intentions on paying my debt back, but it's just right now I'm not in a position.
Okay. All right. Thank you. Anything else?
No, Your Honor. Thank you.
Okay. All right. Ms. Smith, this is going to sound cold-hearted. I don't mean it that way. It's just the quickest way I can say it. Being broke is not a legal defense to a claim.
Yeah.
I'm sympathetic to being broke, but they're entitled to their motion. They're entitled for their motion to be granted today. So I will do that. Council will submit an order to that effect. I want you to understand this, though. If you cannot work out a payment plan with them that you can live with, for example, the most you can pay is not enough for them to agree to, then you can always file with the court a motion for installment payments. What that requires is you actually give me like a little financial statement, sources of income, your regular expenses, and then you show me where you're at financially and say, this is why I can only afford X per month. If I agree to that, I'll enter an order for installment payments, and that will stop any wage garnishments. You hit the lotto, they can still go after your lotto money, but it will stop a wage garnishment. So that always gives you a little bit of a safety net. So they're not coming after your wages and taking 25% of your take home if you can't afford that. Okay. The goal is to set up some kind of a minimum payment while you're broke, so that once you get a decent job and you got some money coming in, then you can up the monthly payment amount. I mean, that's what you want to try to work out with counsel. I just want you to understand that the process available to you at the court is that protection from a wage garnishment. You understand that?
Yes.
Okay. Do you have any questions about the process?
No, thank you.
All right. Counsel, if you'll submit an order for that motion, motion's been granted. And Ms. Smith, good luck in school.
Your Honor, I think we probably have a proposed order attached to the motion. That's typical. If you want,
let's see if we can find that, counsel. We're having a little trouble with our on base this morning, but let's see if we can find that.
Yeah. And Your Honor, I did advise Ms. that she should contact for a payment plan and all of that, but I appreciate your advice as well. Thank you.
You're welcome. You want case number? 02712. See if they got an order for that. We're looking, counsel.
We can email another.
After the 12th? Yeah.
What does it jump down?
Your Honor, I don't see one attached. I just looked at the copy. We will submit.
All right, counsel.
Forgive me. Thank you.
Know how to get back to where I was at.
Permission to leave, Your Honor.
Yes, sir. Have a great day. Yeah.
On the iPhone, what is your name, please?
Lakeisha Payton.
Lakeisha Payton?
Yes, ma'am.
All right. Nobody from Mr. Canine's office appeared, Judge. For Crown Asset.
Yeah, I'm gonna call Sandy, see if she can got anything. Sandy, have you heard from Mr. Canine's office on case number
Hi, on the TCL.
5403?
What's your name, please?
Crown Acid versus Payton.
Oh, Najee Green.
Najee Green, thank you.
All right, thanks.
Mr. Swessinger, would you like to speak to Miss Green?
I think it's necessary, but I can talk to her for a minute.
Okay.
Miss Payton, can you hear me all right?
Yes, sir.
All right, so it's pretty unusual for an attorney not to show up for a pretrial, especially from this office. But you're entitled to a dismissal because they didn't show up today.
Okay.
Probably means they're just going to refile it and you'll have to go through the whole service and file an answer thing, which is fine. I can proceed that way. Or if you want me to, I'll just adjourn it. We'll send another notice out for a pretrial. Your call. You understand the options?
Either way is fine.
I'm sorry?
You said it could be moved for dismissal?
Yeah, I can dismiss it because they didn't show up, or we can adjourn it and save them a refiling and serve you again and that route. Your call.
Well, I received the dismissal in the mail.
Will you receive the dismissal in the mail? Yes.
No, I'm saying I received one in the mail already.
Oh, you received one. Oh, did you work something out with them?
No, the last appearance, because you didn't I guess agree with them. He said that he wasn't coming back.
Oh, okay. Well, they didn't tell us that. So you won.
Okay.
Have a nice day.
You as well. Do I leave, sir?
Yeah, you're all right. You can take off. Have a great day.
You as well. Thank you.
Sent something smart last time. I wish I remember it. Weird the way this is jumping around. Now it should go down to Michigan Dream Builders when I send this, right? Where'd these come from? Well, see, that's another thing I keep forgetting to say. Oh, that's not it. Because it doesn't matter if I sign up from the bottom or from the top. Yeah, see, this one I sent a note 3 weeks ago about that one, but I don't know what happened to it, but it's still Still stays in that review. Oh, like this one? There was no order, so I sent a note back saying there's no order, but it's still, you guys leave this in here forever. Right.
Are you ready on Concord versus Green?
We are.
All right.
Thank you.
Counsel, your appearance.
Good morning, Your Honor. Mark Swessinger, standing in for the attorney of record on behalf of plaintiff.
Ms. Green, you can hear me okay?
Yes, I can hear you.
Good morning.
Good morning.
Counsel, this is your motion. Counsel, this plaintiff's motion is scheduled for today?
No, I'm sorry, Judge. I didn't catch what you said first. This is defendant's motion to set aside.
All right, let's see if we can get a hold of it. Can you find that? Case number 03-23-03081, LT. She filed a motion to set aside judgment. All right, Ms. Green, you filed a motion to set aside a default judgment. Let's see what you checked. Reasons for granting stay. Received notice of hearing late at the time of the hearing. Did not have a working phone. At the time I appeared to court, not in a timely fashion. The judge I talked to was nothing she could do. Okay, so if I understand that correctly, you couldn't Zoom in because you didn't have a working phone, so you came to court in person?
I had used my sister's phone, but I was late, and I talked to the clerk.
Okay. All right, so when somebody files a motion to set aside a default judgment, there are two questions that I have to have answered. One is, did you have a good reason for whatever caused you to have a default? In this case, you didn't show up in court on time. And then the second question is, do you have a valid defense to the underlying claim? Do you understand those questions I need to answer today?
Could you repeat the last question?
Yeah, question number one is, why didn't you do whatever you had to do that ended up in a default? In this case, show up in court on time. And the second question is, what's your defense to the underlying action? You follow me?
Yeah.
Okay. And counsel, I'm assuming, correct me if I'm wrong, this was a non-payment of rent case?
That is correct, Judge.
Okay. All right. So, ma'am, the first question is, why didn't you show up? And I'm assuming this was a Zoom hearing and you didn't show up to the Zoom hearing in time, right?
Yeah.
Okay, so the reason for that was what?
I didn't have a working phone, so I had to use someone else's phone. And I thought it was at a different time than it originally was.
Okay, all right. So you were mixed up on the time and you had to borrow a phone.
Yes.
Okay. Anything else as to why you didn't show up on time in Zoom?
No, that was it.
Okay. Okay. The second question is, what's your claim to the unpaid rent? What's your defense to the unpaid rent?
I had ended up losing my job back in the summertime, and they told me like I couldn't do like breakup payments because I had missed the payment already. So that put me
Right.
like behind. It had put me behind.
Okay.
And I didn't know that it had ended up getting like owned by somebody else, or I would have definitely went to them and talked to them. But by the time I figured it out, I already had got my eviction notice. And they didn't like when I moved in also, like my apartment wasn't move-in ready. Like it was still dirty. Like I had to do all the cleaning. They washed my light fixtures in the dishwasher and it had bugs all in it. So I couldn't ever use my dishwasher since I moved in. So I had like issues and like I didn't have outlet covers over my outlets or like just like little things like that. And I couldn't use my heat.
When did you move in?
I moved in March 2023.
March of 2023?
Yes.
Okay. And when did you quit paying rent? When your finances got tight?
Like July.
Of 23.
That's when I had lost my job.
So you pay rent for about 4 months before your finances got screwed up.
Yeah.
Okay. All right.
But I definitely want to make the payment because I don't want to get evicted and I don't want an eviction on my record.
Okay.
So.
All right. All right. Anything else?
No, not at this time.
Okay. Counsel, any response?
Well, Your Honor, as you indicated, in order to set aside a default judgment, you need to be able to show both good cause and meritorious defense. Defendant was served with a copy of the lawsuit, and she's not disputing that she was served. Hasn't indicated she wasn't served. She was served by first-class mail on 12/16, by posting on 12/21. Failed to appear at the hearing on 12/27. Default judgment was entered. This is a non-payment case. At the time of entry of judgment, there was $7,284.35 in unpaid rent. As defendants indicated, she didn't pay rent after July. Date of the hearing, there was a writ date of 12/14. This court issued writ of eviction at 1/31 at my client's request. There's still been no payment, other than the escrow that was paid in connection with to the court with filing this motion. But I don't believe she's demonstrated good cause. She was served and failed to appear. As to a good defense, I mean, she's indicated there could be some problems. I mean, she mainly talked about losing a job, which unfortunately isn't a good defense. There maybe was some issues at the complex, has produced no evidence that she's made any work request, that she's escrowed rent in a bank or otherwise to cover the outstanding rent. And the current outstanding balance is getting close to $10,000, Judge. I don't believe she's met the requirements under was it MCR 2.60? Boy, I forget, 2.603. We'd request that the motion be denied, Your Honor.
Thank you. All right, Ms. Green, anything else?
No, that'll be all.
Okay. All right, Ms. Green, even if I wanted to stretch it and take what you tell me as a defense to the underlying claim, and it would be a little bit of a stretch for me, I can't find that you had good cause. You messed up on the court date, and you didn't make arrangements so you'd be able to Zoom when you did have to Zoom. So I'm going to leave the judgment as is. I'm sure if you want to work something out, counsel would be happy to discuss whatever you've got to suggest. I mean, they can always stop the eviction on their own if they make a deal with you. If you want to do that now, I can give you some time in a breakout room and have a conversation with counsel.
Yeah, if I could.
Well, Judge, I have
counsel, you willing to have a breakout room?
Well, we did discuss this before we went in. This judge, I mean, I don't have any authority. This client, they took over Concord Club in August. They had a bunch of high dollar arrearages. They're really not willing to work with people if they have any more than like outstanding rent. What I did indicate to her though, and Ms. Green did state to me in the breakout room prior to going on the record that she would have the ability to pay the balance off next week. You know, as Your Honor is aware, you know, doing an eviction costs my client money. So if she comes and says, hey, listen, I'm going to have the money Monday, they may be willing to work with her. The problem that she has, though, is she hasn't paid rent in a number of months. So I'm not sure how eager my client's going to be to accept a promise to pay $7,000 when there's been no payments in, you know, 7 months.
Right. So what I'm hearing is, hold on, Ms. Green. What I'm hearing, counsel, is you can't work anything out with her, but she's more than willing or more than able to go to the management and see if she can work something out with them.
Indeed, Your Honor. Yeah, I have. Okay. Just like at home, I have zero authority.
Okay. All right, Ms. Green, any questions?
I really needed to keep my place because I have another situation with court as far as getting my kids back. So I know that I definitely will pay for it so I can stay.
Okay, I understand that, but your option is to work something out with management. If you can convince management, then you're golden.
Okay.
Good luck. Have a nice
Judge,
day.
When would I have to leave since, like, when would they say like I have to move out?
Do you have a writ now, counsel?
Yeah, the writ has issued.
It was yesterday.
I did look at the online register of actions, and apparently the note in the online register of actions indicates that the court has instructed, is it Rocco, who does your court officer?
Correct.
Hold the writ until after today's hearing. So someone will instruct him, or he'll check in with the court to see what the results of today's hearing were. Generally speaking, he'll go and say, hey, listen, you know, do you have the money? If not, then, you know, I'll give you a day or something to vacate.
Right.
But use that time.
This could happen real quick, Ms. Green. So you want to go on and talk to the management as soon as you can.
Okay.
All right. Good luck.
Good luck, Ms. Oh, Judge, do I need to submit an order?
Counsel. I've got an order, counsel. I'm just getting ready to sign it.
All right, great. Thanks, Judge. Have a good day.
You too. All right.
Thank you.
Let me know. I tried to sign it and I threw this over here. So then I tried to check the box. You know, I don't even. Yeah. Why can't I do that? See the thing I got to do here to get over here. You know, I can't check the box.
Oh, you trying to do the stamp X?
Yeah, yeah, down here. Denied. And I don't know why I threw it over here when I tried to sign it.
Yeah, that's. Looks like it's on this here. You don't have that one.
Minimize
this one. Where the black, or the gray, yeah, drag over more to the left. Yeah, close it out.
Close this one out.
Close this one out.
Shit, I don't know.
We're talking about the motion, right?
Yeah. Yeah, well, you are, but the motion's got the order at the end of the motion. That's all the document.
Yeah.
Heather, you listening?
I am.
You want me to just leave this up for this afternoon?
Well, we're still waiting for, we have 10 more minutes for Mr. Otter to
Ford Motor?
appear. Yeah, Ford Motor's here. We're just waiting for Otter unless she's heard anything.
Hello, this is Deborah Winslow on behalf of Ford Motor Credit. We did speak with Mr. Otter yesterday, and we reached a resolution where he was to pay a settlement amount by March 11th.
You
we
want
had
to just
attempt-
adjourn this, council? How do you
Yeah,
wanna
that's what
handle
I was gonna suggest. If we could maybe adjourn it for like till the end of March and we could get a dismissal with prejudice and then if he pays the settlement.
it? Heather, we've got some date options.
We have the the March 12th or April 16th.
Could we do April 16th? That way we'll have
Sure.
plenty of time.
What time,
9
Heather?
a.m. 9 a.m.
Okay.
Thank you.
Thank you, council.
Thank you. Have a nice day.
You as well.
Thank you.
So I'm gonna leave it up anyhow, Heather?
I'll shut down the, leave it up. I'll just stop